Thank you. Today, I wanted to welcome everybody for attending the Surprise Regional Chamber of Commerce convener meeting. This again, Surprise Regional Chamber of Commerce. We represent 6 cities in the region, and we provide convener events basically to inform the business community about emerging issues and topics that's important. My name is Raul Sada. I'm the president and CEO of the Surprise Regional Chamber of Commerce. So again, I'd like to welcome all our guests. Also, as a brief reminder, today's video presentation will be recorded live and rebroadcast on the Chamber's YouTube channel, as well as our social media. And I also wanted to thank our Chairman Circle sponsors. You'll see on your screen our community investors. These are corporations that have made a significant contribution to the organization. So in order to speed things along very quickly, I'm going to make all the introductions for our key presenters today, and then I will hand it off to Chris, who will be moderating. Chris Herring is the Chamber of Commerce Government Relations Chairperson. As I mentioned, he'll be moderating the discussion. Chris serves as the Director of Student Services, Strategies, and Operations for the University of Phoenix. He is also on the Board of Directors for the Surprise Regional Chamber of Commerce. So welcome, Chris. We also have Alexis Glascock. She's an attorney with Fennemore. She's also the Chamber's paid lobbyist and has worked both in private and senior staff positions in state government. Alexis, in addition to being the chief lobbyist for our chamber, she's the primary lobbyist or the only lobbyist for the West Valley Chamber of Commerce Alliance. She's also lobbied for some organizations you may have heard of: American Heart Association, Arizona Cardinals, and the Greater Phoenix Economic Council. Our 2 featured panelists that we're going to be speaking with and having some conversation with today are no strangers to the chamber. For those of you who attended our convener event back in, that was December, the topic was regarding the recreational marijuana that was passed. And both Josh and John have earned the honors of having the highest watched video in the chamber's history. So that video on recreational marijuana is approaching 28,000 views right now. So according to John and Josh, this video should probably rank up there as well. Real briefly, John Balitis is with Jennings and Strouss. Mr. Balitis counsels private sector clients as well as government agencies, including the Arizona legislature, on a broad range of employment law, labor relations matters. Has over 30 years of practice experience, and he has represented clients in administrative proceedings before the Equal Employment Opportunity Commission, the U.S. Department of Labor, National Labor Relations Board, Arizona's Civil Rights Division, Arizona Industrial Commission, Arizona Department of Occupational Safety and Health, and the Arizona Department of Economic Security. Our other distinguished guest today is Joshua Black with the law offices of Joshua Black. Joshua regularly represents his clients in both state and federal court and appears in agency proceedings before the U.S. Department of Labor, the Equal Employment Opportunity Commission, Arizona Attorney General, Civil Rights Division, the Federal Merit Systems Protection Board, and the National Labor Relations Board. Joshua also makes media appearances related to employment law and has been a featured guest on Fox 10, 3TV, CBS 5, NBC 12, ABC 15, KJZZ, and KTAR, and other news stations discussing employee rights. So that's our lineup for today. We'll try to be we'll keep this meeting going. And with that said, I'm going to go ahead and turn it over to Chris, who will then let Alexis say a few opening comments. There you go, Chris.
Thank you, Raul. Well, thanks everyone that's watching today. We are going to get into a hot topic for all of us with COVID liability protection. So this applies to you if you own a business, if you work at a business, if you're visiting a business. So just about all of us. And we're going to talk about what this means and what you should be aware of. First, we do want to go to Alexis. As Raul said, Alexis represents us down at the state legislature as our lobbyist, not just for our Chamber of Commerce, but for 6 chambers of commerce here in the West Valley of the Phoenix metro area. And so, Alexis, you are very well aware that this was one of our top priorities coming into this legislative session was to get some form of guidance and ideally some form of protection for businesses and other organizations around COVID liability. And so can you share a little bit about the work that was done and how we got to where we're at today?
Sure, absolutely, Chris, and thank you for giving me a few minutes to just tell you a little bit about the work we do down at the Capitol. So in terms of this bill, this was the #1 priority for really both the president of the Senate and the Speaker of the House, as well as the governor. And the way that the chamber gets involved is actively interfacing with not only leadership, who we meet with every session multiple times, but also with other legislators from the West Valley to make sure that they are on point in terms of the messaging that that they are getting from the business community, and that they're focused on those. And this bill was hugely important. It's very few states have passed anything like this, and I know that John is we'll talk quite a bit about this, but it really was a big victory for the business community. So in terms of what the Alliance does and how I represent the chambers that make it up, and that's Glendale, Peoria, the Southwest Valley, and the Southwest Valley is Avondale, Goodyear, Tolleson, Litchfield Park, as well as Buckeye Regional and Wickenburg. It's a big group of chambers. So we're working diligently to convey to those members that we want to attract new businesses and really high quality workers to the area. So, and the other part of that is really trying to limit regulations, government regulations, or other intrusions that are going to hinder the business community's ability to really meet the needs and demands of consumers and employees. So in addition to meeting with members at the state level, we also interface with the congressional delegation. We are constantly sending them letters, either as the Alliance or the individual chambers, advocating for things at the federal level that are important. We did that quite a bit during the with all of the PPP initiatives that they were undertaking, but also most recently with the efforts to let them know that we're not supportive of the chambers. The Alliance is not supportive of the American PRO Act, which would really lead to a lot of unionization, increased tremendously throughout the country. Those are the kinds of issues that we bring to the attention, and through Raul's action alerts, and as well as webinars like this that are put on for the members, we're able to bring to them the information they need in order to make informed business decisions, but also to reach out to their legislators. We make a real effort in the newsletters that if they need to talk to a member, if there's an issue, to let them know how to do that. So that's just a little bit about the work we do down at the Capitol, and I will turn it over to your speakers today. And thank you again, Raul.
Thank you, Alexis. All right. Well, John and Joshua, we're going to go to you now. And we're going to talk a little about this law and what it does. So let's start with the basics. And I'm going to go the opposite. Normally, I say take the legal and put it in layman's terms. I'm going to do the opposite, because we've been given the layman's terms. This is being called a liability shield, which in a courtroom, liability shield is a nice word, but right, it's not something actually in the law. So explain to us more in legal terms, what exactly is this looking to accomplish, this liability shield?
Josh, care if I start?
Go ahead.
The best, what I found is the best way that we can describe what this bill does is sort of talk a little bit about what it changes, okay? And let me tell you what I mean. If you're involved in a car accident, or you slip on something at a grocery store and you're injured, what you would do at that point, if you wanted to, in prosecuting a claim, is you would seek compensation from the person who ran into you or the person who owned the grocery store. And when you would do that, the standard you would have to meet as the claimant who has been injured is what we call a negligence standard. What you have to do is you have to show that whatever the other person did to harm you was not reasonable. It wasn't what the average person would do. And when you would go to court to prove that claim, you would just have to put on your evidence as basic generic evidence, okay? What this law does is it changes those two standards. It heightens those standards. And what it says is if you're a business owner, and then there's a separate section for healthcare professionals, and someone claims that you are injured because the business didn't take necessary precautions to protect you, the negligence standard no longer applies. Now what you have to show is that the misconduct on the part of the business was willful or grossly negligent. And that standard is not only heightened, but you have to then prove that if you go to court by clear and convincing evidence. So it changes the framework of what you would have to go through in order to prove your claim. And by heightening those standards, it's designed, as it's been reported in the media, to exclude frivolous lawsuits. So we have to understand that it's not complete immunity. It's not a liability shield in the sense that no one can be sued if someone catches COVID at your business site. What it means is that it's much harder for the person who catches it and is injured to prove their claim. Gross negligence, willfulness, and clear and convincing evidence. And that's how the bill accomplishes what it's set out to do, by manipulating those standards.
So Joshua, help us a little bit, because like I said, I started with the layman's term liability shield, and John did a good job of telling us the more legal terms. So let's go now the opposite. Let's go back to taking legal terms and help us understand them. Negligence is typically the standard. This bill says gross negligence. Give us some idea of the difference in those standards for something like a COVID case.
Yeah, absolutely. I think that, that's a good question, because that's instantly what people are going to want to know, right? Okay, so what is it that I can do that would be considered negligent versus gross negligence? What is that difference in the standard? And for the most part, it's going to be something that I think is subjective. So it's going to be based on the circumstances. An example, I think, of negligence versus gross negligence would be, I own a business. I failed to even look up the CDC guidelines as far as what I should be doing to keep people safe. That's pretty negligent. We all know if we have a business, or if we're in the population at all at this point, that there's a virus going on and that there's safety precautions. We see people with masks. So I would say, as a business owner, if I had never even looked up what the rules are or what the suggestions are, that's probably negligent. Grossly negligent, on the other hand, might be me getting something in my hand that says, hey, it's very dangerous in your area. It's a COVID hotspot. Here's precautions you can take. And I say, I don't have time for that. That might be the difference between being negligent and grossly negligent. If you've been put on notice that there's a specific issue, like for instance, a hotspot, and it's right there in your face and you took steps to ignore it, I think that's either grossly negligent, or that would border on the willful misconduct, which is a higher standard. But willful misconduct would absolutely be, I know what the requirements are. And let's say for political reasons, I disagree with them. So I'm going to flaunt the fact that I will not follow COVID protocols. That would be willful.
Yeah, those are great examples.
Yeah, thank you for that. You stole a question I had for later, but we can still get to it. So let's talk. So one of the arguments against this, when it was being debated in the legislature, was kind of the balance between consumer protection, right? Person going and customer at the business, and the liability protection for the business. And, I think in our day-to-day, we don't think about that. One of the times I know for myself that I think about liability protection is if I'm going to a business, they make me sign a waiver. I think we've all done it. Those in the call, I'm sure you've done it. You go skydiving, you go paintballing, right? You're going to go in the shark cage, whatever, something where you might get hurt. You sign a paper that says, hey, if I get hurt, and usually, thanks to our lawyers here, it says ridiculous things like, if you die, I'm not at fault, right? And that's a liability waiver we're all familiar with. And I think some would say, well, is this now a de facto liability waiver that we've all just signed? Is it essentially a enter your own risk now, and all businesses kind of have this waiver signed because, what the legislature and the governor passed here? Is it that black and white?
I don't think so. I mean, because the bill doesn't approach it from the standpoint of the customer. It's not saying, you are signing your rights away. All the bill is saying is that you still may have a claim, which theoretically a waiver would completely wipe out. But the bill says you still may have a claim. We are just saying, as a matter of policy, the legislature, the government is saying, we are going to make it a little more challenging for you to succeed if you decide to pursue it. So that's the distinction for me between a waiver, which is a complete waiver, a complete giving up of a right, and just something like this bill, which simply makes it a little bit more, requires a little bit more deliberate action on the part of the claimant to prosecute a claim.
Okay, no, very good. I think that was one of the arguments that was coming out in the legislature. And unless you're a policy wonk that likes to watch committee hearings, probably didn't see all of that. But for our employers and then again for the general public that watches, I think it's important to know you didn't waive a right. You still have a right to a claim. It's just the burden has to be a little more significant, and
Right.
And you can't just say, well, I got COVID and therefore I'm suing. So, all right. So let's talk about, and you mentioned this a little bit already, Joshua. Let's talk about how a business might void this. I think that's a really important thing for all of our members of the chamber, our business owners, things that a business might do that would lessen the protection of this liability shield. So what kind of activities would they want to avoid?
Well, I think the first activity that a business would want to avoid is flagrant disregard of COVID precautions. So I mentioned that as an example a few minutes ago. If you're someone who is not a fan of the public policy that we have regarding COVID, that's fine. That's your prerogative to feel that way. You can take reasonable steps at your business, meaning as long as you're being normally cautious, you don't have to overdo it. It's your business. But I think that what you need to be careful of is flaunting this idea that, hey, a lot of people think I have freedom of speech. That means I can say and do what I want. That's not really what that's talking about. And especially when we're looking at something that's statutory, that's a law that's written. As a business, you have to be careful to comply. So my main concern would just be if someone's out there and specifically touting the fact that they are not following COVID protocols, that would be something to steer clear of. Beyond that, businesses, I don't think have a lot to worry about. The typical business should be taking precautions to make sure that their folks are safe, to make sure their customers are safe. We've been going through it for a year, so I would say most businesses have a good idea of what that is. If you're at a point where your business is thinking you want to start scaling back those precautions, I would make sure that you're in line with the majority of businesses in your industry, that if you're scaling back, that it's something that seems in line with the majority, that you're not out of the major group. If you're doing something that's ahead of everybody else, you're probably risking more liability. You're at least going to have that argument to be made that, hey, if the whole pack is doing this and I'm over here doing this, that could be negligent. I mean, again, we have a higher standard to get to, as John was saying, but it's still a claim that can be made. So you still want to make sure you're taking reasonable actions like you always should.
But
Chris,
John, go ahead.
I just say the flip side of that is, like, you can say, well, what should businesses avoid? The corollary to that is, well, what should they be doing in order to take advantage of the protection? And if you look at the bill, I mean, we talked about the heightened standard for evidence and the heightened standard to gross negligence from regular negligence. And that really sort of addresses the standard for the misconduct and what you have to prove in order to succeed on a claim. But when you read the bill, the way it starts out is it says, a business will not be liable for an injury that's caused by the virus to a customer or a client or a visitor if it acts in good faith in protecting the customer, client, or visitor. And then it says you are presumptively acting as the business in good faith if you take reasonable steps to follow guidelines that have been put in place by the federal government, the state government, local government, and so on. So it keys right into what Joshua was saying, because if all this guidance is out there, You just need to find it, read it, and take reasonable steps to abide by it. And as long as you do that, a presumption arises in the statute that you're okay. You're okay. Now that's rebuttable, but I mean, it's still that as long as you take those reasonable steps, you should be okay. And so I think that's important to sort of think of it in the reverse, if you will.
So I want to talk a little bit about speech versus actions and then the material burden. And I'm trying to use as many, I think, real world scenarios as I've seen. So, you know, on social media, I feel like we've all seen instances of businesses, like Josh was earlier, flaunting their view, say in opposition to some of the restrictions or some of the guidance. If a business was to do that, but to still say, have the hand sanitizer available, have their employees wearing masks, would the speech be enough to show bad faith? Or is there a material burden to actually show some kind of more tangible action taking place in the business?
Well, if I'm going to take a stab at that, I think, Chris, that the speech in and of itself, if it does not match the action. So if they're saying we're anti-COVID, you know, we think this is fake, for instance, we think masks don't work, but yet they still are asking people to mask up, you know, they've got a sign at their door and they have hand sanitizer. Well, then, you know, I think you'd be hard pressed to say that they're not acting in good faith for the recommendations. I mean, the CDC doesn't say you have to agree with us that COVID is real or agree that masks work. I mean, a company can have their public viewpoint on COVID, and as long as they're taking reasonable precautions, I don't see why that would necessarily be a problem. Now, if you were going to get sued and you had made those comments versus having a client who had not made those comments, I would much rather have a client who had not made those comments, right? I mean, it's just going to be something that will be considered, but I don't think it would be fatal.
Yeah, I agree.
Okay.
Yeah.
So let's talk about masks a little bit. I feel like somehow we always come back to masks. Maybe it's just the most public of the guidelines that we interact with. You know, there are businesses now that are not requiring masks. You know, the governor has you know, an order out there saying, you know, the state is not requiring them any longer, and local municipalities are sometimes in conflict with that. If a business right now is not requiring a mask, and say a customer comes in, was able to trace their contact back to that business, would they be protected with the current guidelines that are out from the state?
Well, you know, I think that's kind of the way the governor tried to resolve the discrepancy between his philosophy on this and the mayoral philosophies on it. You know, the Kate Gallegos and the mayors, for the most part, have really pushed local mask mandates. And Governor Ducey has really wanted, I think, to leave it more in the hands of the business people. And his latest executive order then basically put that in black and white and said, it essentially says, notwithstanding what any mayor says in Arizona, I'm saying, as the governor, that it's the business owner's decision about whether to require a mask. And nothing any mayor, I mean, this is paraphrasing the order, but nothing any mayor says or does is going to trump this, because I'm the governor. And so to get to your question, so then you have a restaurant or a store, and they see the executive order and they say, oh, it's up to me now. Like, even if you're in Tempe and there's a Tempe mask mandate, the governor says, as the business owner, I get to decide. So no masks, because I don't like them. Well, this goes right back to the presumption of good faith that we talked about a few minutes ago. In order to be presumed to be acting in good faith, you have to take reasonable steps to comply with guidance. And although the governor has given businesses the freedom to decide, the flexibility to decide what they want to do, I still think if you look at the lion's share of the guidance, CDC and so on, they are still recommending masks, distancing, and everything else. So I'd be a little apprehensive if I was a business owner thinking, I can take this executive order and it's my get out of jail free card, because Governor Ducey said I can do what I want. This is what I'm doing. I don't know about Joshua can comment on it, but I don't think that would get you there, because there's too much other Dr. Fauci, CDC stuff out there that you really should be abiding by.
Josh, I want to give you a chance. I want to add a little bit more to it and say, what if it wasn't a customer? What if it was an employee? Because an employee, right? Employee is not necessarily there by choice. I mean, they are choosing to stay employed there, but say it's an employee that gets COVID at his place of employment, and same thing, there was no mask requirement. Is the employer protected?
That's a kind of a different analysis, Chris, because employees' rights were already limited when it came to getting COVID at work. And this bill doesn't really change that. As employees, for the most part, we don't have the right to sue the company that we work for when we get injured. It's not like if we slip at the grocery store or if we're hit by a car. If we're injured at work, we have the workers' compensation system, and that's how we take care of those injuries, whether it's, we broke our arm or theoretically, whether it was something like COVID exposure. So I think that that's something that is certainly a little up in the air too, because you can imagine insurance companies, which is what work comp is based on, they don't necessarily want to take on extra liability. So I think that there's some concern there that that the workers' comp might give pushback, but most of the opinions out there right now are that that's where an employee would have the right to take that claim. So they'd have a right to get their their health care covered and maybe potentially get some pay for the time they were out of work as a work comp claim.
Yeah, Chris, to that point, if you look at the literal language of the bill, which I'm looking at right now, right beneath the section that talks about everything we've discussed so far, good faith, presumption, gross negligence, clear and convincing evidence, there's a separate subpart that says, this section does not apply to any claim that is subject to Title 23, Chapter 6. Title 23, Chapter 6 is Arizona's workers' compensation statute. So this bill basically says, we're not changing anything that Joshua just said. If you're an employee and you get it, you're covered by workers' comp. This bill has nothing to do with you. And what the Industrial Commission said at the beginning of the pandemic, back in the middle of last year, so it was soon after the pandemic started or really became the strongest in like March, is that the Industrial Commission was going to look at every employee industrial injury claim relating to COVID on a case-by-case basis. And like Joshua says, if you think you got it at work, your remedy is workers' compensation. You can't sue. And by the way, the standard for employer liability outside of the compensation scheme is kind of the same standard that this new bill establishes. You got to be willful or grossly negligent, almost contribute to or cause the injury willfully in order to, as an employer, take yourself out of that workers' compensation scheme. It's pretty much, as a worker, you're pretty much limited to workers' comp.
I think it's an important point. I'm not sure that all of our, especially very small businesses, understand that it does not apply necessarily to employees. And I think also to employees, I've heard that from different sources, again, through social media and things of, what does this do now? I can get sick at work and I can't sue. And I think it's an important distinction that this is essentially, like I said, a differentiation between consumer protection and business liability, not workers' compensation. So
absolutely, yeah.
Excellent distinction from both of you. So let's talk a little bit about the other portion of the bill. We focus on the business here with the Chamber of Commerce, but there's some other subsets that are mentioned. Schools, hospitals, including things like, clinics, dentists, things like that. And then there's also some for religious and nonprofits. Let's start with schools. I think out there, because Arizona, in our landscape, some schools are a business in Arizona, whether they're private, whether they're for-profit, charter, and then obviously we have our largest, our district schools. So with schools, with children in schools, what does this bill do with liability there? Parents sending their children to school, what's covered, what's not?
Well, I think that the main point of listing out these types of entities in the bill is just to identify that they're all enjoying this same kind of liability requirement. So what's happening at schools and hospitals, and John can step in if he has more to add, but as I see it, it's all the same. And that's what this bill is saying, is that essentially, if you're sick from, going into a business and they were not grossly negligent, you can't sue them. If you're sick from going into school and the school wasn't doing anything grossly negligent, you can't sue them. And so that's really the distinguishing factor for the school. I think it's just solidifying that they're on that list as well of folks that are going to be held to this higher standard before there's a liability. There's more additional details for hospitals and healthcare about, well, what happens if they're taking care of COVID patients and can't take care of other patients? And there's limiting liability there as well, but that's a little different than the schools and the religious institutions and other employers and companies.
Yeah, the
So
bill
John,
kind of, the bill sort of, it's redundant in the sense that it lists it defines the word provider, and then the bill applies to providers. But a provider, we normally think of like as a healthcare provider, but provider, according to the bill, means a school district, a property owner, a nonprofit, a religious organization. It goes on and on. The bill covers all those places. And then in terms of the person who may get injured, it covers customers, students, tenants, volunteers, guests, neighbors, and so on. So it does it both ways, because it says, this protection, these heightened standards and the protection that they afford apply to schools. And by the way, if you didn't understand that, it limits liability if a student gets injured. So it's very clear that it applies to pretty much everyone and everything, once again, with the exception of employees who are covered by workers' comp.
So I want to stay on the topic for a little bit, because here in Surprise and in our footprint for the Surprise Regional Chamber, hospitals or healthcare providers and schools are I'm going to say largest employer. I could be wrong, but I believe I'm accurate and up to date. That those two categories would be our largest employers. I have a kid that's going to go into first grade. We've been shopping schools here in Surprise, and if my information's out of date, anyone in the comments can correct me. But as my recent knowledge is that we do have schools that are not currently requiring masks, and we do have schools that are requiring masks for both teachers and students. What would the guidance be? And I feel like I've heard it already, but it sounds like there is still a bit of risk assumed by a school that would not be requiring masks, because there are other schools that are. Is that fair to say? Yeah, you're shaking your head. That's I love when a lawyer gives me a yes. That's great. Josh, anything to add there? Is it just that simple?
I think it's just that simple. If you look around and the other schools are taking significantly more protective measures than you, that's something you want to be concerned about. It's going to be that simple. Yeah, you're more likely to be liable because the opposing side is going to be able to point to all those other schools and say, they all understood that wearing a mask could help. You're the only one that didn't. And our plaintiff here is a dead first grader. I mean, that's the lawsuit. That's who the school is going to have as their plaintiff in that scenario. So it's going to be, my first grader died, and she wouldn't have died at any of the other Surprise schools, only at yours. Is that enough to establish gross negligence? Not necessarily, but again, it doesn't sound good, and it's not a good place to start. And it certainly could be one of the building blocks for them to put together a case and say, overall, you were grossly negligent.
So from a risk standpoint, there is additional risk added on by that, simply by the comparison of like institutions. Okay, I think that's very good. Like I said, I know we do have chamber members that do operate schools here in Surprise, so I think they'd be very interested to hear that. All right, well, we're about 40 minutes in, and I am not one to drag things. Those were the specifics that I wanted to make sure we went over today. I do have one that I want to close with, which is it might be a little bit out of your scope, And if it doesn't apply, then it'll be short answers. But that comes down to the federal level. This is an Arizona state law that we've passed. Some other states are considering it. There has been a push, and there's been lobbying efforts from the U.S. Chamber, from a lot of other organizations at the federal level to pass some federal COVID liability protection similar to this. With that not yet being the case, is there a separate set of liability for businesses not covered by this at the federal level?
Can you say that one more time, Chris? That last part?
Yeah. So what I was saying is there a separate level of liability that would not be covered by this state law at the federal level? Would there be a class action liability potential? Would there be some other federal liability that is not protected because it's a state law and not a federal law?
Not as it relates, I don't think, to contracting the virus. There's all sorts of other potential liability that isn't covered by this bill at the state level that, a business could run into relating to COVID. For example, you could have a worker who says, I have a disability and I can't wear a mask. And the employer then would have to, if the ADA, the Americans with Disabilities Act, applied to that business, they would have to go through the ADA analysis and see if there really is a disability, and if so, could it be accommodated? And the same thing would apply for people who don't want to be vaccinated for religious reasons. You go through the same analysis, and if you don't do that and you just refuse, there's liability, and that would be liability at the federal level. But in terms of this particular bill, Joshua, you can chime in. I'm not aware of the same type of claim, I got infected at your business or whatever, that could then be pursued more successfully or more easily under federal law than what this bill now restricts people to under state law. I'm not aware of that.
I'm not aware of any, John, and I don't see any interplay there. I mean, if you got COVID and then the employer started mistreating you because of it, because your health wasn't 100%, that again could fall under something like the ADA maybe at that point. The other issue that that comes to mind, which could be federal, could be state, would be OSHA or ADOSH. There's obviously an idea as an employer that we need to keep a safe working environment. So if part of what you're doing, for instance, is not wearing masks, employees do have the ability to call ADOSH, the Arizona Department of Occupational Safety and Health, and they can make a complaint of an unsafe work environment, just like if there was mold or something like that. And so I think that you could have potential liability or at least exposure there where you could have an investigation or something like that if what you were doing was significantly out of line with standard safety precautions.
One thing, Chris, that we might want to add, it's not directly related to the last question you just asked, but I was reminded of it the other day. I was looking, we get a report through my office every day of all the lawsuits that have been filed in the state of Arizona the previous day, everywhere, all across the state, federal and state. And before Governor Ducey signed this bill, which has just been a couple of weeks, I think, there was a whole set of lawsuits. There were like 2 or 3 days of them, 3, 4, 5 lawsuits a day that had been filed against nursing home facilities by families of impacted residents. And the allegation was that you didn't protect the resident against COVID-related risk. Then Ducey signs the bill. And the question that arises out of that is, did those people get in? Sort of, did they slip in before he signed it? Before these new heightened standards have been established? And interestingly enough, if you read the bill, it applies retroactively back to March 11. So he just signed it a couple weeks ago, but ironically, all those lawsuits that I saw that got filed, people who filed them probably didn't even realize it, he signs the bill, but even though the lawsuits were filed before the bill was signed, they are still, these heightened standards still apply to those people. So for your chamber members, you need to know that this protection starts on March 11, despite when the bill was signed. So prior to March 11, if a claim arose, it may be a different story, but the bill actually became effective on March 11.
Of 2020, I'll add that, John. So right, March of 2020. So yeah, any of the COVID or the majority of the COVID pandemic will be covered. So as a business owner, you can rest a little assured knowing that, you know, any claims anybody might have had over the last year, they're all going to be beholden to this new standard.
Right. Yeah. March 2020.
Actually, that's a very good point. That's not one that I had picked up on, but you're right. As a business owner, that's very good to know, since oftentimes those claims come out well after the actual incident occurs. So that's a very good call out. Thank you for bringing that up, John. Okay, well, I will allow you both, as I did last time, a closing thought. If there's something that you haven't brought up, and maybe that was what it was for you, John, but I'll allow you both a closing comment, and then I'll make a couple closing remarks, and we will pass it back to Raul to close down the video. So, John, if you want to go first with any other closing remarks, I'll give it to you first.
I'll just mention, this was something that we chatted about before we actually went online with the presentation. The chamber members should know that there is a bill pending at the legislature that would prohibit businesses from requiring vaccinations and prohibit businesses from requiring customers, clients, and visitors to prove that they've been vaccinated in order to enter. It's in the Senate Commerce Committee right now. It's been there for a few weeks, but it's a piece of legislation that I think you all should keep your eyes on. Keep watching the media about it. I don't really think it's been that widely reported yet, but if it gains some traction, some momentum, and it looks like it's going somewhere, I think it'll be, the media will probably report on it a little more aggressively. If it were to be passed, you would really want to know about that, because if you're a business that is mandating vaccinations, or if you're, you know, the type of business that would require somebody on your premises to show that they've been vaccinated, this would stop you from being able to do that. So just something to keep in mind.
All right, thank you. Joshua.
Yeah, I would say absolutely. I would kind of echo what John's saying. It's something that I find very concerning as far as the bill itself. My firm is also watching that and watching it for the implications it has for businesses, including our firm, which is a small business here in Arizona. The idea that the legislature is going to decide whether or not you get to exclude certain individuals from your business should be a very controversial topic. Whatever side of it you're on, that should be controversial, because as a business owner, obviously the idea is that we're pursuing our own freedom and we're running our own company the way we want to, and we have our own sort of kingdom, right? That's the idea, is that we get to build this entity and we create products we want, we create services we want, and we choose who our customers are. And so anytime there is an outside entity telling you that they're going to limit that, specifically if it has to do with your safety or your family's safety, it's pretty interesting and something definitely to be aware of. So I think that's a great topic to follow. And I suppose the other advice I would give to companies is look around at what others are doing and do the same thing if it's reasonable. And nobody's enjoying COVID. Nobody's enjoying the restrictions. Everybody's employees are tired of COVID. Everyone's customers are tired of COVID, but it's not going to go away. And it's certainly not going to go away if we ignore it. And as a business, the last thing that you want is to have any liability with COVID associated with you. COVID's a terrible thing, but it has nothing to do with your business. we're all out here just trying to make sure our businesses survive and that we can pay our employees and that we can continue delivering our products. Don't let the idea that you're tired of COVID interfere with your business. Keep doing the right thing, keep having folks be safe, and you won't have any liability issues to worry about.
Right. Well, thank you, Joshua. Thank you, John. Thank you, Alexis. And for both your closing comments, I can tell you that with Alexis, our lobbyist, still on, and Raul on, they'll definitely be taking this back to the other chamber CEOs to look at and to track. And I have no doubt that some of our members will be inquiring about it. And we'll definitely be watching that other bill. To sum up kind of my thoughts from the day and the main takeaways I have, it's definitely that this is not a carte blanche, do what you want around COVID type of protection here. There still needs to be due diligence. There still needs to be practical application of guidance, and that our employers, our members, the businesses out there should be looking at the community at large, as well as federal and state recommendations on COVID. And you can't piecemeal and just take what you like. So we may get more questions afterwards, and we welcome those from any of our members or other business owners that are out there. But thank you all so much. And Raul, I will hand it back to you to close.
Okay, well, thank you, Chris. I want to thank John and Josh and Alexis for joining us today. I wanted to remind everybody on the call that we're having a no-nonsense networking event, which is perfect for business owners and your employees on April 22nd. Dr. Tyner, who's president of Ottawa University, will make some opening comments during that. And one of the things you guys need to know about those no-nonsense networking events, these are not Zoom calls. This is some specially designed software that the chamber has been using that allows for one-on-one direct private conversations with people in 3-minute increments. It's kind of like speed dating, but this is speed networking. The computer pretty much takes over. You have the opportunity to electronically change business cards. So really, in the age of COVID, it brings back a very personalized experience. So I'd like to encourage you guys, if you haven't already done so, April 22nd, go to the chamber calendar and register for that event. And the final comment for everybody is you should have received an event survey. I would encourage everybody to get it, fill it out, and we do listen to and we do react to the survey comments. So again, on behalf of the Surprise Regional Chamber of Commerce, I'd like to thank everybody for attending today, and we'll see you at the next Convener event. Thank you, guys.